Hi, everyone. It's Mimi Rocah here for Talking Feds. And I want to talk to you today about grand juries. And in particular, something you may or may not have seen in the news because there's so much going on. And it's definitely not the biggest thing that happened, but I think it's important and worth diving into a little bit. The District of Columbia U.S. Attorney's Office, which in any time, not just this extraordinary time, handles both federal and state crimes, had charged a man with assaulting a federal officer, or under a statute that we call assaulting a federal officer. It can also be impeding, obstructing justice, or some kind of lawful use of law enforcement resources. And the charge, there's a video that's out there. So the reporting is that the charge was based on his having thrown a sandwich at I believe, ICE officer. And, he said something not nice to the ICE officer. I want to start by saying, as a federal prosecutor, I indicted and oversaw many cases about assaults on federal officers and other kinds of bad conduct towards federal officers. And I am no way condoning them. And in fact, when I was a supervisor, I took a very broad view under that statute because it meant a lot to our law enforcement partners to know that we were looking out for them. And because they do put their lives and security on the line every day when they are out there working on cases in legitimate ways. And so I do think that these statutes about assaulting officers, whatever kind of officer we're talking about, federal officers, state officers, should be taken very, very seriously and have a broad brush by prosecutors. However, what happened here seems to be, based on everything that we're taking together, and I'm going to explain why, it seems that in this case, the U.S. Attorney in Columbia, who's Janine Pirro, probably got a little too broad and exercised discretion in a way that was not commensurate with the law or the way that prosecutors should use their discretion. How do we know this? Because the grand jury did not return an indictment in this case, even though it was submitted to a grand jury. And again, this is based on reporting, lots of reporting. There's a lot of information, even though it's a grand jury proceeding, there is a lot of information out there. And so I'm saying all of this, assuming that reporting is all correct. But of course, we weren't in the grand jury. We don't know exactly what happened, but it does seem confirmed that they submitted this indictment against this man for throwing the sandwich, and that the grand jury did not return what's called a true bill. Why is this newsworthy? Because that almost never happens. Prosecutors get indictments, I think, in like 90% of the cases, if not more. And that's at the state level, the federal level, really almost any jurisdiction you're talking about. Why is that? Well, there is this saying that a grand jury will indict a ham sandwich. That's part of why this case has been the result of, or has led to so many jokes, because we're actually talking about a sandwich. And the saying is a grand jury will indict a ham sandwich. I actually have never thought that saying was true. And when I was the district attorney in Westchester, I would go and address the grand jurors often, and I would thank them for their service. And in doing so, I would explain to them what an important service they were doing. And what I would say is, I know there's this joke about, a grand jury will indict a ham sandwich and they're just a rubber stamp. But the reason that's not true is because the grand jury serves a purpose before the prosecutors even walk in the door. Why? Because we know prosecutors, I say I still think of myself as a prosecutor sometimes. We know we are going to have to present our case to you, ordinary citizens. And so we make decisions about what cases should even go to a grand jury based in part on this notion that the grand jury is there and is going to be a check on us. So most of the cases we bring to the grand jury are cases where the prosecutor in charge has already done this sort of self-check and self-screening of, one, are there the facts that meet the statute, the requirements of the law? And two, should I be using my prosecutorial discretion to bring this case? And that's actually why so many cases end up being returned as true bills and getting indicted by grand juries, because there's this whole sort of self-selection, if you will, or screening process that goes on because of the presence of the grand jury. On top of that, once you're there, the grand jury actually gets to scrutinize evidence and testimony. We don't know exactly who or what they heard, or saw beyond the video. Here in this case, there could have been other witnesses, or could have been, evidence about statements that were made or not. But clearly, they had an issue with something in the case. It could have been the issue of intent. Did he really intend to hurt or obstruct or impede what the officers were doing, or was he just blowing off steam? I don't know. I wasn't in the grand jury, nor were the prosecutors when the deliberations were occurring. But it is so highly unusual for grand juries not to return this indictment, an indictment that prosecutors bring to them, that is why it is generating so much discussion. It's sort of making red flags go off, because when you see the video, you look at it and you say, okay, even under the best of circumstances, and again, we don't know all of the evidence, this is a on the line kind of case. Are you really going to charge this as a felony? And the other reason that it's generating so much discussion, aside from the whole sandwich pun, is that it's not the only case that reportedly this office in very recent time, this U.S. Attorney's Office has had a rejection, not gotten a true bill. There was a case of a similar but different about a woman who was charged with assaulting a federal officer. And that one, apparently, according to the reporting, involved more of a scuffle between her and the agent, where there was some physical encounter on both sides occurring. The agent ended up having some kind of scratch on his hand, and there was a charge for that. And apparently they tried to present this indictment to 3 different grand juries, which again is so very unusual. I don't know that I ever saw that in my 17 years as a federal prosecutor or my 4 years as DA. I'm not saying it never happens, but it is something that you have to go up to the highest levels to get approval to do within DOJ. Which obviously they did here, but that's for a reason, because usually once you don't get an indictment, you sort of say, okay, let me rethink whether this is the right case to bring. Maybe you go back again one more time, but 3 times is really unusual, and then they never got it. So all of this together, the sandwich case and this case, the repeated presentation of the one case, and the fact that in both cases they never got indictments is a sign that there's something wrong in the process before they even get to the grand jury. Something wrong in the screening process, something wrong in the decision-making process in that U.S. Attorney's Office under this particular U.S. Attorney now, Jeanine Pirro, in terms of how they're using their discretion. There's so many things going on with the DOJ right now. Why is that important? Because I think, first of all, it tells us there are still checks and balances that are working. The grand jury is not one that most people necessarily think about as a real check, but it seems to be. And as we know, DC is sort of a ground zero, for this interplay between legitimate law enforcement, which I am a supporter of law enforcement. I think there are so many legitimate things that law enforcement can and should be doing. But sometimes, they can be asked to do things beyond their normal routines, and it causes friction in a way that I think we're seeing somewhat in DC, and it is leading to some of this tension then in the grand jury. And the last thing I'll say is that we can't ignore, frankly, the hypocrisy here of this administration. This is the same administration that not only dismissed cases against January 6th defendants who assaulted, who threatened, who really tried to, in serious ways, hurt police officers, hundreds of them on January 6th. They not only dismissed those cases, but they pardoned or gave breaks on sentencing to those defendants, and then tried to punish the prosecutors and FBI agents who worked on those cases. So on the one hand, we all should take seriously, definitely, the idea of prosecuting when warranted violence or attacks on law enforcement. But we have to do that in an equal-handed way, not just when it sort of satisfies our political agendas, and which is what it seems like it's going on here. So that's my explainer on the sandwich guy. I hope it's been a little bit enlightening to you. Thanks for listening. For Talking Feds, Mimi Rocah.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.